In the legal system of each state, cases involving will disputes, elder financial abuse, and breach of fiduciary duty are initially argued in probate and chancery court. These are their stories.
Hello, I'm David Russell, editor of wealthandhonor.com, and welcome to Wealth and Honor, the Case Files, where we undertake a non-legal analysis of actual court cases involving will disputes, elder financial abuse, and estate litigation. Now, before we get started, let me remind the viewers that I am not a lawyer. My commentary should not be taken as legal advice or expert legal opinion. If you find yourself in circumstances such as what we're about to review, you should hire a lawyer licensed in your state to advise you. No, the reason for examining these cases is to learn from the mistakes of others and hopefully keep ourselves, our clients, or our loved ones out of the courtroom. Most advisors will tell you that the courtroom should be the arbiter of last resort. But we do have these public records, these stories to learn from. And so my intent is not to air another family's dirty laundry or to gloat in their misfortune, but to look for the warning signs that our own families might have in common with these. We'll look at the parties involved, the context of their lives, and the decisions that were made that may have led to conflict and litigation. Perhaps their experiences will spare your family from avoidable conflict later on. Before you watch this episode, if you've not viewed the presentation on frequently used terms in the case files, I recommend you watch it first to familiarize yourself with many of the terms used throughout the case files. As with each episode, characters identified in the court transcripts are portrayed as characters in popular TV sitcoms or dramas. I think this gives the characters depth and often adds a touch of humor to an otherwise serious legal matter. For now, I hope you enjoy this episode of Wealth and Honor, the Case Files.
Background facts. Alfred P. Douglas died in March 2001, leaving a substantial estate. He was survived by his wife, Parnice Douglas, and his two children, Jackie Douglas and Deborah Bowen. Alfred's will established the Alfred P. Douglas Trust. Parnice was the primary beneficiary, and, upon her death, the trust assets were to be distributed to Alfred's living descendants. The community estate was valued at $1,700,000. Alfred's one half was valued at $850,000. The trust account was funded with $673,000 in an account at Edward Jones in Sweetwater, Texas. The initial co-trustees were Parnice and John Bergstrom of Edward Jones. The trust produced an income of approximately $33,000 in 2002. Bergstrom invested the trust assets in tax-free municipal bonds because Alfred did not want the trust to invest in risky assets or to pay taxes on its income. According to Bergstrom, Alfred wanted the trust assets to remain invested and increase until both he and his wife had died. After Alfred's death, Jackie Douglas became the primary caretaker of Parnice. He lived in the same town as Parnice and farmed his own the land and land owned by Parnice. Jackie died unexpectedly in October 2002. He was survived by his 3 children, Dana White, Cody Douglas, and Michael Douglas. Bowen became the caretaker of Parnice after Jackie's death. In October 2002, the month that Jackie died, Parnice executed a statutory durable power of attorney naming Bowen as her attorney-in-fact. The power of attorney gave Bowen the power to handle all of Parnice's financial affairs. In the summer of 2004, Bowen and her husband moved into Parnice's home and became her full-time caretakers. John Bergstrom was asked to resign as co-trustee of the trust, and Parnice appointed Bowen as the successor co-trustee. At the time Bowen was appointed co-trustee in May 2004, the balance in the trust account was $620,065. Within 3 years, Bowen had reduced the trust account to $12,000. It had taken Alfred and Parnice a lifetime to build an estate of $1,723,000. At the time of Alfred's death, Parnice had inherited $188,000 from Alfred, and her one half of the community estate was valued at $862,000. Thus, in addition to being the primary beneficiary of the trust, Parnice had assets of $1,050,000 when Alfred died in March 2001. When Parnice died in March 2006, 5 years after Alfred died, Bowen had reduced Parnice's assets from $1,050,000 to an estate of $603,000. All of Parnice's investments in bonds and cash had disappeared. At the time of Parnice's death, the trust had assets of approximately $376,000, but Bowen as trustee did not distribute one half of the assets to Jackie's children as required by the trust provisions. Bowen ultimately distributed all of the remaining trust assets to herself. By December 2006, the trust only had a balance of $124,000. The Edward Jones statement for January 26, 2007, reflects a trust balance of $0. The trust provided that the co-trustees could distribute income and principal from the trust to Parnice, as necessary, when added to the funds reasonably available to her from all other sources known to the trustee to provide for her health, support, maintenance and education, taking into consideration her age, education and station in life. The co-trustees, in their discretion, could also make distributions from the trust to any of Alfred Douglas's descendants under the same terms.
Parnice had significant funds reasonably available to her from sources other than the trust. Parnice also had a separate account with Edward Jones in the amount of $293,000. In addition, Parnice owned approximately 1,100 acres, and she was earning income from a lease of the land to Terry Lee Coker. Parnice also had income from Social Security, income from her IRA account, and a separate banking account. Shortly after Jackie's death, Bowen and Parnice opened a joint checking account with right of survivorship at Edward Jones. Bergstrom had concerns because the joint tenancy account could be used to avoid the equal division provisions of the trust. Bergstrom's concerns were justified. In August 2003, $60,000 was withdrawn from the trust account and put into the joint account. Bowen testified that the $60,000 was to help Bowen and her husband. A total amount of $329,000 was withdrawn from the trust and placed in the joint account by April 2006. Expenditures utilizing trust funds included a 1998 GMC Yukon SUV titled in Bowen's name, many pieces of farm equipment, several farm tractors, several trailers, trucks, jeeps, an old Cadillac, a sand buggy, a Caterpillar bulldozer, a trailer to carry the bulldozer, an asphalt spreader, a case backhoe, and many other items. None of the items were ever titled in the name of the trust. On February 17, 2006, a month before Parnice died, trust funds were used to purchase a $25,000 motorhome from Fun Time RV. Bowen said that she sold the motorhome after Parnice's death and kept the money. 2 days before Parnice died, Bowen used trust funds to purchase a classic Thunderbird for $25,000. Bowen sold it after Parnice's death, realizing a $9,000 profit. Bowen kept the proceeds. There were a number of checks, funded from trust funds, in the amount of $3,000 payable to the Office of the Standing Trust in connection with Bowen's bankruptcy restitution payments. Bowen explained that, at the time of Parnice's death in March 2006, Bowen was still paying $3,000 a month to her creditors in bankruptcy. Bowen testified that the construction business she owned with her husband had filed for bankruptcy in 2002. Although Bowen testified that all of the trucks, jeeps, trailers, a dozer, and a backhoe were purchased for the farm, a more reasonable inference is that Bowen purchased them with trust funds for her construction business or for the benefit of her and her husband, not for the benefit of Parnice. Bowen testified that Parnice wanted to get back into farming after Alfred died in 2001. Both Alfred and Parnice were 81 years of age in 2001. They had quit farming years before. Terry Lee Coker, who lives in Roby near Sylvester, testified that Alfred had turned over the farming to him. There is no evidence that Bowen or her husband knew anything about farming. Farming, a risky enterprise, was something that Bowen and her husband wanted to try. It was not for the benefit of Parnice or to provide for her health, support, maintenance and education, taking into consideration her age, education and station in life.
Shortly before Parnice died, Bowen contacted an attorney, David DeFore, to prepare a new last will and testament for Parnice that would leave all of Parnice's estate to Bowen. DeFore testified that he prepared the will at Bowen's request but that he never spoke with Parnice. By having Parnice execute a new will in Parnice's final days, Bowen made certain that Jackie's children would not participate in any of the assets that Alfred and Parnice had accumulated. Dana White, daughter of Jackie Douglas, brought charges against Bowen. The indictment charged Bowen with a first-degree felony under Texas Code Section 32.45. The jury returned a unanimous verdict that, as a fiduciary, Bowen had intentionally, knowingly, or recklessly misapplied property of more than $200,000 owned by Dana White or held for her benefit. Bowen was sentenced to 8 years in the Texas Department of Criminal Justice Institutional Division, assessed a $10,000 fine, and ordered to pay restitution in the amount of $350,000 to Dana White and her brothers. On appeal, Bowen argued that the state's evidence was legally insufficient to prove she committed a first-degree felony because there is insufficient proof that over $200,000 in trust assets were owned by Dana White or held for her benefit. Had the indictment listed the other trust beneficiaries as owners of the equitable or beneficial title to the trust property and as persons for whose benefit the property was held, this would be an easy case. However, the indictment only listed Dana White as the owner of said property, and the person for whose benefit the property was held by Bowen as a fiduciary. We find that the record is legally insufficient to support the verdict that Bowen misapplied over $200,000 of trust assets owned by Dana White or that were held for the benefit of Dana White. It appears that at most only slightly over $100,000 of trust assets were owned by Dana White or held for her benefit, and the jury charge did not include a lesser included offense. Bowen is therefore acquitted of the charges.
Well, with apologies to the late Eddie Albert and Ava Gabor, and all the wonderful cast of Green Acres, I hope you enjoyed this presentation of the facts of this case. Seems that not all was well down on the Douglas farm. This is a sad outcome for a family that one can imagine as a salt of the earth family, a loving family, and probably a family that you wouldn't have guessed would go through this had you known them when the kids were growing up in the Douglas household. Now, it's hard to imagine that Deborah and her niece and nephews would even talk to one another. And we can even have compassion for Deborah. Yes, she was acquitted of the criminal charges brought against her on a technicality, but she must live with the fact that her own family brought charges against her and that a jury of her peers were unanimous in believing she misappropriated funds that she was responsible for. She was probably a caring daughter and was simply tempted by easy access to money she felt entitled to in order to solve her own problems. It's too easy to simply blame Deborah for what went wrong here. So let's take a deeper look to see what could have been done to have avoided this outcome. Now, before I point out what went wrong, let's at least give Alfred and Pernice credit for what they did right. They did have an estate plan, which is more than I can say for the majority of Americans. They had powers of attorney in place and had worked with a financial advisor for several years, one who Alfred apparently trusted enough to serve as co-trustee of the trust for Pernice's benefit when he died. It seemed to be a solid plan. Having said that, there are also holes in their plan that ultimately made it possible for Deborah to gain control of the assets of the trust, as well as Pernice's own assets, and misuse them to her own benefit. As always, my comments are based on my own observations and opinions, and should not be used to make legal decisions of your own without the guidance of a qualified lawyer licensed in your state. Now, the biggest problem I see is the trustee arrangement. While having John Bergstrom as a co-trustee adds a degree of objectivity as it pertains to the administration of Alfred's trust, the fact that Pernice had the power to replace him with Deborah totally defeats the purpose of having a third-party co-trustee in the first place. And presumably he was appointed by Alfred because Alfred trusted him to be an objective voice in the management of Alfred's trust and provide a balance of power to Pernice with regard to disbursements from the trust. Now remember, the trust specifically stated that Pernice or any of Alfred's descendants, Deborah included, were entitled to funds from the trust for health, education, and maintenance, but it also put a burden on the trustee to disperse funds only if there were not sufficient funds from other sources available to the beneficiaries. By replacing Mr. Bergstrom with Deborah, this meant that two trust beneficiaries were also serving as co-trustees, and to use a farm pun, this was like asking the fox to guard the hen house. Perhaps a better alternative would have written the trust such that if John Bergstrom was to be replaced, he could only be replaced by either an unrelated individual or a corporate trustee such as a bank or trust company, but not with another trust beneficiary. This would have kept a disinterested party as co-trustee, and one who would have been required under fiduciary laws to comply with the terms of the trust. In addition, the power to appoint a successor trustee could have required the consent of all trust beneficiaries, which would have included Jackie's children after Jackie died, giving them a voice in whoever was to replace John Bergstrom. I've had many conversations with attorneys who tell me that when clients have to choose who they want to serve as trustee of trusts created in their estate plans, the default choice is to choose a family member. This is a default choice because most people don't like the thought of having a professional trustee, especially if it's a trustee with whom they have no personal relationship. How could a bank or trust company possibly know what that person wanted or what their actions would have been towards their heirs? Now, this is understandable. However, there's often denial on the part of the persons creating the estate plan that their children would ever disagree over money or behave in such a way that one might take unfair advantage of the other. If there is an axiom of life, it's that sudden money changes people. Now, bad things happen to good people, and when it does, it's very natural for these good people to look for easy ways out of difficult situations. We don't know Deborah's heart. What we do know is that she had financial problems and that she abused her position as trustee of Alfred's trust and agent under Pernice's power of attorney to find an easy way out of her own difficulties. My question is, why would we ever put someone we love into such a tempting situation in the first place? Until next time, I hope you've enjoyed this episode of Wealth and Honor, the Case Files.